My name is Jeff Buhman. I'm the Executive Director of SWAP. And you may not know, a few years ago, SWAP was the Statewide Association of Prosecutors, and we had failed to renew our name with the state. Some kid swooped in and stole it, so we renamed ourselves Statewide Association of Prosecutors and Public Attorneys. Well, we've since swiped the name back, but we've still stuck with SWAP as a larger entity. As Executive Director of SWAP, myself and members of the SWAP Board and members of SWAP-LAC work with the legislature to try to pass good legislation and blunt or kill bad legislation. So right at the beginning, I want to make a pitch. So if I could introduce John Nielsen. Where's John? Not John Nielsen, I'm sorry, you were it. Will Haynes. Will Haynes. John Nielsen was the SWAP-LAC director until about 2 years ago, or 3? Okay, yeah, 4 years. Has it been that long? Will Haynes is our director of SWAP-LAC. So real briefly, SWAP is a board, and you generally have to be a county attorney or president of UMPA or UMA or a designee of one of these organizations to be on that board. There's also a couple seats for line prosecutors, 3 seats, a felony, a misdemeanor, juvenile. But much of the work in legislation is done in SWAP-LAC, the Statewide Association of Prosecutors Legislative Action Committee, which Will Haynes directs and does a wonderful job. My request is, if you have any interest in legislation, and by that I mean if you care about your fellow citizens, because is Representative Stoddard in here? Sometimes the legislature feels like they don't care about regular citizens. They pass laws that are not very good. If you care about your citizens, which I know you do because you're prosecutors, I would invite you to join SWAP-LAC. It does a really good job of helping guide legislation with the legislature. So let me tell you a little bit, real briefly, why SWAP and SWAP-LAC are important. I'm going to give you 3 good things and 3 bad things that kind of happen in the legislature. The bad things didn't actually happen because we have SWAP and SWAP-LAC. You already know about some of them. The first is HB 229. If you recall right, this is the large white-collar financial crimes bill. Craig Barlow got great credit for that, which was well-deserved. We are going to have some significant changes to how we deal with our big white-collar crime cases and offenders. This has been years in coming. SWAP was able to help support that and help it get moving. And that's Representative Brammer in the picture there, who is out of Utah County, Pleasant Grove area, and he's the one that sponsored that bill. Representative Pitcher on the top one, we've already talked about that one, transfers domestic violence cases. Again, she is a prosecutor at Davis County. She is one of the authors of this idea, along with other prosecutors. Great bill for our victims. The third one, DUI penalty amendments. This is something that we have been talking about for many, many years. That's Representative Nielsen at the bottom who ran that bill. It will allow us to prosecute second DUIs as Class A misdemeanors. These are just 3. There's dozens of bills that SWAP, Salt Lake District Attorney's Office, UPC members, SWAP-LAC, it's a team effort, but these are 3 that I thought were really great. Now let's go to some of the bills that we were able to kill, fortunately, or blunt. This is Senator Weiler, who actually does run some great bills too. This is one that we feel very strongly was not. SB 231, this would have taken our preliminary hearings back 25 years, about 25 years or so. It would authorize defendants to cross-examine witnesses regarding credibility. It would allow the judge to weigh credibility. It would allow defense to conduct discovery. It would effectively eliminate 1102 statements. We know this bill is coming back next year. So we already have a group formed, and if you're interested, we invite you to join our group. But it's already we know it's coming back. This is a big, big interest of the defense bar to get preliminary hearings, in their view, to have more meaning. And by doing that, they want to talk about credibility and do discovery and things like that. So we were able to kill it this year. And I say that our Senator Wilder was really good. He didn't really try to push it. He just wanted to open the door, which he did. And we need to make sure that we are there for the party. The second one, public prosecutor modifications. This is Representative Christopherson out of Lehigh. Again, he runs good stuff too, but this is a bill that had he had some particular interest in. It was actually drafted by a former prosecutor. This bill in its original format would have taken a lot of authority from prosecutors. Number one, as you can see from the first bullet, if you have 1,000 offenses, you got to file 1,000 charges. And if you do child porn cases, I mean, there's a variety of cases where we commonly will not file all the cases. I think Donna Kelly talked about that yesterday, how you may have had a victim sexually assaulted or over years. You can't file all those. Your jury will hate your guts. So this would have required us to file all of them. It would have prevented pleas in abeyance for everything except significant evidentiary problems. It would have gutted the pretrial diversion programs that I know at least Salt Lake and Utah counties are experimenting with. It would have really hurt county attorneys who are elected because any of the violations mentioned above would have been considered malfeasance in office. And as someone who was an elected county attorney, there are always people out there who don't like what you do with cases and are looking for some way to get you out. And even if they can't win, doesn't mean they don't want to go through the process. And then it also would have greatly prevented or impaired our ability to plea bargain appropriate cases, as you can see on that last bullet. So those are some of the two of the really, in my view, bad bills that we were able to blunt. The third one died pretty early in the session. This is Senator Kennedy. He's actually my senator. He's an attorney, physician, really sharp guy. He had a constituent come to him and ask him to run this bill. I don't think his heart was in it because he was pretty quick to kill it. But this would have, we called it the Bring Your Sex Offender to the Park bill. It would have allowed sex offenders into restricted areas. So we adamantly opposed that one and forced it one away very quickly. So again, my pitch is if you're interested in legislation and helping your citizens make sure that we have good laws, please contact Will Haynes or myself, and we'd love to have you join. We also have many committees that work during the interim. So for instance, the Law Enforcement Legislative Committee, which is comprised of the chiefs of police, the sheriffs, the state, the AG, us, state police, I mean, a number of these bigger entities, they've already got 5 committees that are going to be running over the interim. We are looking for volunteers to help with those committees. I haven't put them up, but if you're interested in working during the interim, and these aren't usually very big commitments. We're talking about a Zoom meeting or a meeting in Salt Lake, depending what's your preference, once every other month commonly during the interim. But these have real effect on legislation. I'll talk a little bit in a minute about Title 24, which is the Asset Forfeiture Act, kind of. And that was the product of a large group of prosecutors and other entities working on it. It resulted in a very ugly bill. That's a very ugly law, but it was a lot better than we would have gotten if we hadn't been deeply involved. We would have not had civil asset forfeiture in Utah at all unless we had been actively engaged in that process. So let me shift gears a little bit. That's my pitch for SWAP. I have been tasked to talk a little bit about the disposition of firearms by police agencies. So I think Will Haynes, who was talking about restitution, and I are competing for the most boring topic of this conference. Are you on it too? I didn't read my notes. But hopefully I'm going to be in second place, but I'm not sure. But I will keep it short because we're a little bit behind. Hopefully, as a prosecutor, you will not have to deal with this very often. And here's the takeaway. I'll give you the bottom line up front. If, as a prosecutor, a defense attorney says, hey, I want my client's firearm back, the first thing you should be thinking of is Title 24. If you're not familiar with Title 24, I'm sorry for you. It is a very poorly written statute, and I'm culpable in part because I was part of the group. It wasn't the drafting attorney's problem. It was getting a herd of very disparate opinions together and trying to create something. If they want a firearm release, think Title 24. Second, you may have to file a petition in court to release that firearm. We have to file a petition when the owner of the firearm is the offender or the firearm was used in the commission of the offense. And I'm simplifying a little bit, but basically that's the rule. You'll have to file a petition. The third takeaway is if you don't have to file that petition because it wasn't used in an offense or the offender is not the owner, then you have to notify the law enforcement agency that possesses the gun that it's ready for disposal. And hopefully they'll go to their own attorney and figure it out. But if you're like a county or city, they may call you anyway. So before going too deeply into this, because I'm not going to go very deep, I have all the statutes kind of laid out in the materials. So if you're really interested in getting a little deeper dive, you can go there. But let me do some quick things. There's 3 ways you may get a firearm into a police agency, right? Search and seizure. If that's how you got a firearm into that police officer's hands, you're going to be looking at Title 24 when it comes to disposing of it. If the firearm was truly lost or abandoned, then you look at Title 77. The third way, which I doubt anybody has had yet, is under the Firearms Safe Harbor Act. Has anybody had a firearm come into their agencies under that yet? It's a pretty new law, and there's notes in the materials, but I won't spend a lot of time on it. All right, Title 24. Like I said, it's been an arrest or a probable cause. The property is evidence of an offense, has been used to commit an offense, or is proceeds of an offense. The takeaway from this slide is that you, as the prosecutor, can tell the law enforcement agency when that firearm is available for release. There was some ambiguity about that before, but that is clear in this title that it's up to the prosecutor. And you can hold on to it until all retrials, all appeals, all that time has lapsed. But the one funky thing Title 24 did is it has a little clause in it that allows the owner to seek release of that firearm even if you still want it, even if you still need it. So again, I think most judges will shut that down pretty quickly. You just need to be aware that it is a possibility. Okay, so here's the normal. You're done with a firearm, appeal's over, or the appeal time's over, there's not going to be a retrial. If the owner committed the offense, or the owner cannot lawfully possess it, then you have to petition the court for a transfer. But if it's not one of those 2 prongs, then again, you just notify the agency that it's available for release. Now, we don't have to release firearms that are contraband. And I was trying to think of what that would be, and I think it's normally firearms that are without a serial number, and maybe some really high-tech machine guns or something, I don't even know. But in Utah, you can actually possess machine guns, so I'm not sure. Does anybody know what would make a firearm contraband other than no serial number?
If it was too short.
You can get an exception for that, I believe. A license for that, I believe.
It's all about the inches.
Yeah. So there's a couple ways. Anybody else know of another one? Not too many ways. All right, so if you don't need the firearm for evidence, and let me go back just real quick. This is referring to that bottom right code section. If the property is a firearm and you're unable to locate the rightful owner or the owner cannot possess it, then you dispose of it per this code section, 24.3-103.5. So you can see that you can dispose of it, but the way you can dispose of a firearm is limited. You cannot just say, hey, prosecutor, you did a great job on the case, so the sheriff gives you the firearm. You cannot even sell it to your employees generally. Title 24 talks about how you can do it. And basically the bottom line is you're going to have some sort of agreement set up with a federal firearms dealer to accept and sell those firearms. That's generally how it's going to work. One caveat again, if you have a firearm as part of a homicide, you may be able to destroy it if you consider it a notorious crime. All right, let's move on from Title 24. Again, if you have questions, good luck going through Title 24. It's really pretty rough read. If you have a firearm that was truly lost or mislaid, Title 77 gives you the answers on what to do with that firearm. If it's not claimed by the owner, and you cannot find the owner, this is what you do. After 3 months of holding it, the agency can publish a notice of intent to dispose. You got to do some certain things to publish that notice. And 9 days after publication and posting, if no one makes a claim, then you can dispose of it. You can apply it to public use with the approval of your city or county council, sell it at public auctions, and apply the proceeds to public interest use, or you can destroy it. Again, my recommendation is, even though it's not explicit in the lost or mislaid firearms section of the code, I would still recommend that you go through a federal firearms dealer. There might be parts of the state where it's okay if you put on your public auction site that you're selling firearms, but I think generally the mood of the public is probably better if we sold them through a federal firearms dealer. All right, the last way you can dispose of firearms is if you get the firearm under the Firearms Safe Harbor Act. You know, I won't talk about this too much, but it's because it's a fairly new law, but this allows a cohabitant or the owner of a firearm to bring in their firearm to a law enforcement agency if you or your cohabitant believes that you're an immediate threat to yourself or others. And that allows you to voluntarily put the firearm into the custody of that law enforcement agency. Either you, if you're the owner of it, or if you're the cohabitant of the person who owns the gun, you can do that. Now, there's not a lot of teeth to this. If the owner of the gun comes into the law enforcement agency and says, all right, I may be civilly, well, that's probably not a good example, but all right, I am really angry, but I want my gun back, the law enforcement agency has to give it back. There's really nothing they can do unless a crime has been committed. Unless it's an illegal firearm, which is going to be rare. And that's it. If you have more questions about those, yeah.
I recently requested Sheriff's Office to return a firearm to a defendant who was driving with a measurable controlled substance. And they said they couldn't return it to him because of Brady restrictions. I'm just wondering how this law meshes with federal firearm issues.
Well, if the owner cannot lawfully possess it, and I don't think it's Brady they're referring to, it's another act. I know Bob knows it. Where's Bob? If it's a domestic violence offender who's
driving with measurable controlled substance.
Do they have a qualifying conviction, though, for something that would prevent them?
I don't know. I didn't look deeply into it. I was, when it said Brady, I wasn't looking at it.
I'm sorry, for those online, the question is, I'm sorry, what was your name?
Wayne.
Wayne had a request from the sheriff's office to dispose of a firearm, or you had a request to dispose of it, the sheriff said?
I requested the sheriff's office return it to the defendant because the case was closed.
Yeah, the request was to the sheriff's office to dispose of the firearm because the case was closed. The sheriff said they couldn't do that because of a Brady issue. I guess we need to dig into what they mean by a Brady issue, because I'm not sure what they meant by that.
Isn't Brady the name that they give to the idea of background check? Yeah. Like sometimes you think of Brady in this crowd and you're thinking Brady Bill that we're talking about a background, the federal.
Oh, the Ronald Reagan shooter? Is that the Brady we're talking about? Yeah. Well, again,
I guess maybe you're considering him to be a drug user if he was convicted of driving under the influence of marijuana or some other drug. That might disqualify him under a background check.
They said there's a Brady issue. That's the background check. They run one of those checks every time. They give a gun back to someone. If they don't pass the check, they don't give it.
So that, under Title 24, if they cannot lawfully possess it, you file a petition for disposal of the firearm. Eventually you can sell it through your federal firearm dealer. So you would have to file a petition in that case. Any other questions? Enjoy the materials if you have any others, because they're kind of boring. Thank you.